Court of Appeals. We appreciate council's cooperation in getting these cases rescheduled from the infamous storm day. We have two cases set on our docket. I see counsel in our first case, People v. Harrison, are set up and ready to proceed. Does either of you have any questions? For purposes of our spectators, if any of you has a cell phone or similar device, would you please turn it off so that the lawyers are not interrupted during their argument? On that basis, we're ready for argument in People versus Brittany Harrison.
May it please the court. My name is Jessica Sommer, registration number 50860, and I represent Ms. Brittany Harrison. I would like to spend the majority of my time today focusing on issue 1 in the briefs, the sufficiency of the affirmative defense of overdose immunity, but if you have questions on any of the other issues, I'm happy to take those at any time. The central facts here are not in dispute. Ms. Roberts called 911 because she wanted medical help after she found Ms. Harrison and her friend slumped over and passed out at the Burger King that she managed. Her staff could not wake them up. They were unresponsive. They pounded on the table, they shook them, they yelled, and they didn't move. They didn't even flinch. After Ms. Roberts called 911, police arrived. Again, they couldn't wake the pair. Finally, after shaking Ms. Harrison hard, officers were able to wake her up. But her friend could not wake up. He went to the hospital with paramedics. Based on these facts, there's no evidence to support a reasonable conclusion that Ms. Roberts did not report in good faith an emergency drug overdose. No other element of the affirmative defense is in dispute. Ms. Roberts cooperated with law enforcement, she identified herself, and she remained at the scene. And the Attorney General makes no argument that this offense did not arise out of the same course of events as the overdose. This element contains both a subjective and an objective component. It requires a subjective good faith report of an event that is objectively considered an overdose. The question here is, at the time of the report, did Ms. Roberts call to get help for what reasonably looked like an overdose? The good faith element here refers to whether the call was made for a proper purpose. It's the absence of fraud or pretext. It does not refer to whether she had a good faith belief that an overdose event was occurring. And a good example of this is in State v. WSB, the New Jersey case cited in the answer briefs. It talks about bad faith being if you don't actually think something's wrong and you take someone to the hospital in order to get them out of criminal prosecution. That's what the good faith element is meant to talk about. It does not refer to Ms. Roberts' belief in the overdose.
Is that even contested here, that there was any element of bad faith on her part?
No, that was in response to the court's question about whether the good faith element was subjective. I just wanted to make clear that while it is subjective, it does not refer to her belief. And here, Ms. Roberts called to get help. She was unwavering on her point that all she wanted when she called was to get help. She testified that she was concerned for their well-being and maybe we need to get help. She thought something could be seriously wrong and her emergency bell was ringing. Help was at the forefront, and she was concerned that something was wrong with Ms. Harrison. It does not matter that she called for a welfare check. When you look at her testimony in context, she was differentiating between a criminal check and a welfare check. So all she was saying was that I wasn't calling because they were trespassing or loitering. I wasn't concerned about theft. My concern was about getting help. And the objective part of the test is whether there was an overdose. And subsection 5 defines that by whether there was an acute condition that a layperson would reasonably believe to be a drug overdose that requires medical attention. Here,
Well, I mean, I assume there are a wide range of medical circumstances that would lead to someone passing out. So what
Sure.
is it about these facts that would lead a reasonable person to suspect a drug or alcohol overdose as contrasted with any one of innumerable other medical conditions?
well, These were two young people. These weren't older people who might have other medical conditions. These were early 20s, late teens. So you wouldn't expect them to be having a heart attack or a diabetic coma or something else that might lead to that conclusion. They were slumped over each other. They weren't just passed out or drowsy. This was they weren't intentionally going to sleep here. They had ordered food, and yet they had not even touched it. It hadn't made it out of their bags. And most people know that this sort of decreased level of consciousness is a common sign of overdose. And both police officers here, when they arrived at the scene, who testified as lay witnesses, explained that as soon as they saw Ms. Harrison and her friend, they believed them to be on drugs. So I think there was evidence that this was something that a reasonable layperson would believe to have been caused by drugs.
Well, if the burden's on the prosecution,
Correct.
how does the prosecution essentially disprove that a reasonable person would equate these observations to drugs? I mean, would they have to call a medical witness who could recount a dozen or, for all I know, 10 dozen other medical conditions that lead to loss of consciousness?
I mean, they could do that. I think also, like, context is really important. The fact that these are young people at 10 a.m. at a Burger King, I think in the era of the opioid epidemic is something that is really important to what most people would think when they're just seeing that situation. And they could have elicited more information about what exactly that context looks like, but here they did not. And a layperson observing this would also have believed it to require medical attention. The fact is that Ms. Harrison and her friend presented in a nearly identical condition. There was no differentiation between her and her friend, yet her friend needed to go to the hospital with paramedics. So it does not matter that Ms. Harrison was ultimately able to wake up. That, she was fine after police woke her up is besides the point for the statute. The statute talks about at the time of the report whether it reasonably looked like medical attention was required.
Do we know how long they had been unconscious there before a call was made?
The testimony is not super clear on the timing. I think it's at least an hour. There's definitely, she tried once to wake them up. They couldn't wake them up. They kind of left them alone. They tried again to wake them up. They couldn't wake them up. It wasn't completely clear, but it's some period of time. It's not just, oh, look at those people asleep. I can't wake them up. Maybe I'll call to get help. They did not wake up for some significant period of time.
So why wouldn't we let the jury make the determination in this case where there was evidence that it never crossed the manager's mind that it was drug-related, that the paramedics were not originally dispatched, that the defendant never received medical attention, that when the police officer, the corporal came in, that the defendant woke up and answered questions?
Sure. The evidence wasn't in dispute here, so there aren't facts for the jury to find. This is really a legal question of whether the evidence presented was sufficient to meet that legal standard. And all of those factors relate to, or many of the facts that you just mentioned, relate to things that we know afterwards. And the question that's asked in this element of the affirmative defense is about the time of the report. So that's what we really need to look at. There's also evidence here that the jury was very confused. They asked 5 questions about the affirmative defense. So in this case, it doesn't make sense to just leave this to the jury because there wasn't actually a factual dispute for them to find. So here, even though Ms. Roberts testified that she didn't understand this to be a drug overdose, she also testified she has no experience seeing people who are on drugs or alcohol. That's not what a reasonable layperson has those experiences. Most people do. So the fact that she in particular did not necessarily understand it that way shouldn't really weigh on this consideration when subsection 5 clearly lays out a reasonable person standard. I think also her testimony was mixed on this. You know, we look at it in the light most favorable to the prosecution, but she wasn't simply saying, oh, that had no idea. At some point, she said she thought that she had taken too much of something. I think the upshot of her testimony really was, I didn't really care. I didn't really know. I just knew they needed help. When she said it never crossed her mind, she said, it never crossed my mind because help was at the forefront. She just wasn't thinking about the root cause of the situation she was observing. All she really wanted to do was get help for two young people who looked like they really needed it. I'd like to, if you have no further questions, I'd like to reserve the remainder of my time for rebuttal.
Good morning. May it please the court. My name is Trina Taylor, and I represent the people in this matter. My attorney registration number is 47194. Ms. Harrison was charged with possession of heroin, methamphetamine, and paraphernalia after a Burger King manager called 911 to report that two people were sleeping in her lobby. A properly instructed jury considered whether Ms. Harrison was immune from prosecution in this matter and concluded that she wasn't. Sufficient evidence supports this conclusion. I will also spend the majority of my time talking about this issue and answering the court's written questions. I want to start with the statutory language and the court's second written question. The statutory scheme creates immunity for a person who reports in good faith an emergency drug or alcohol overdose event to a law enforcement officer, 911, or a medical provider. And then that immunity, provided that the other subsections are met, extends to the person who also suffered the drug overdose. The definition of emergency drug and alcohol overdose contains three components. It's an acute condition, including but not limited to physical illness, coma, mania, hysteria, or death, resulting from the consumption or use of a controlled substance, and that a layperson would reasonably believe to be a drug or alcohol overdose that requires medical assistance. I agree with Ms. Sommer that there is both a subjective and objective component here. There's an objective component in the definition because a layperson must reasonably believe this is a drug or alcohol overdose that requires medical assistance. And I also agree that subsection A contains a subjective component. I don't agree that the subjective component, I don't agree that the manager's belief as to whether it was a drug or alcohol overdose is irrelevant here. I think the General Assembly, when it enacted this statute, the purpose in its legislative declaration was to encourage persons who would otherwise be reluctant to report such an event due to fear of criminal prosecution to do so without delay.
But hasn't the General Assembly made clear in another section in this area where a subjective belief of the reporter would be taken into account specifically, and I'm talking about 18.1.712 that deals with the with administering the opioid antagonist?
I can't speak to that off the cuff and would be happy to supplement if you would like, but I think...
No, but let me read it to you and see if you agree with the language. It says, a person other than a healthcare provider or a healthcare facility who acts in good faith to furnish or administer an opioid antagonist to an individual the person believes to be suffering. Isn't that a subjective component written into the statute?
Yes, that would be one way to phrase a subjective component.
But we don't have that in our statute here.
That's true. But even if the manager's good faith, I also don't dispute that she called in good faith, but even if she did not believe or was unclear as to whether this was a drug or alcohol overdose event, the evidence still is sufficient to support the jury's determination.
So are you asking us to write that language in then that I just read to you into this statute?
I think that's a reasonable way to interpret this statute. I don't think that that is a necessary way to affirm what the jury did here. The
Counsel?
evidence...
Excuse me,
Yes.
I'm sorry. Are you then, I just want to clarify that you're not contesting that the charges then arose from this incident, like was contested below, is that correct?
No, that's not an argument that we pursued on appeal.
Okay, all right, thank you.
And so the standard of review is important here. The court looks at this evidence as a whole and in the light most favorable to the prosecution and asks whether it's sufficient to support the rational conclusion of the jury. Here, the jury may have concluded that Ms. Harrison wasn't suffering from an acute condition or that the subjective or objective components were not met. And any of these would be supported by the evidence. The manager here testified that Ms. Harrison looked okay when she was ordering. There was no evidence that she was intoxicated. She ordered okay, she paid for her food okay. She did seem tired, she testified, which makes sense then later when an employee tells her, "Did you know you have people sleeping in the lobby?" And when she describes that interaction with the employee, they said sleeping. "Did you know you have people sleeping in the lobby?" The manager did describe having her porter attempt to wake them up, but she described shaking them as just barely touching their shoulders. And you can imagine in a customer service context, that's probably accurate, that they would just, lightly tap their shoulders and attempt to wake them up. The manager then waited for a while, which might indicate to the jury that she didn't think this was an emergency. 911, in response to her call, did not dispatch paramedics. They dispatched police officers. The manager's explanation of her 911 call was that they came in and ordered and now they're sleeping. And yes, she had some concerns, but she didn't articulate anything that led 911 to believe that they needed to send an ambulance at that point. The manager said that when she expected when the police arrived that they would say, "Okay, you can't sleep here. You need to go ahead and go." She expected that they would be able to wake her up. She also testified that it never crossed her mind that they had taken drugs. She said that she didn't see them ingesting anything. She didn't smell anything unusual. She didn't see them with any paraphernalia sitting out. And they weren't suffering any other symptoms that might indicate that they were something other than deeply asleep. There was no testimony that there were any problems breathing, no convulsions or seizures or vomiting, eyelids fluttering, moaning, lips turning blue, or anything else that would suggest this was something other than sleeping. The officers confirmed that they were called by dispatch in reference to people sleeping, and one of the officers used that term, called in reference to people sleeping. So even though the manager had some concerns about them and she wasn't sure what was going on, the jury could conclude that a reasonable person would not jump to the conclusion without any other context here that they were suffering from a drug overdose. She just didn't know what was going on, and a reasonable person who encountered people sleeping in Burger King would reach the same conclusion.
Counsel, do you agree that they were asleep for a substantial period of time?
I think, yes, the evidence supports that it was at least an hour. I would agree with that.
And wasn't there a second, I mean, you can say touching their shoulder or shaking them, but wasn't there a second attempt by the Burger King staff
Yes.
to intervene and awaken them, which was also unsuccessful before the manager called 911?
That's right. I think that the reasonable juror has also had the experience, though, of going into a fast food restaurant and seeing people who appear to be perhaps homeless who have purchased something and then taken a nap in the store. And so it's not unreasonable for the jury to have concluded that something like that to a reasonable person might have been going on.
Would that be a reasonable conclusion to make about teenagers?
There are certainly runaways, yes.
Okay.
I thought I had read that there were loud comments trying to arouse them and they didn't even flinch or something.
They said something to the effect of, "Hey, hey." Yes, I don't know. I don't think there was testimony about exactly how loud that was, but yes, they did speak to them, and I think they banged on the table a little bit. But again, the jury, everyone has experience with people who sleep more heavily than other people. And so without any other context, without seeing something or smelling something, or something to indicate that this was a drug overdose, a reasonable person would not reach that conclusion. And it's not just a reasonable person reaching the conclusion that they need medical care. It's that they need medical care because of a drug overdose, and that's in the definition. I would also note that the jury very carefully considered this issue because they asked 5 questions. And I don't know that that indicates confusion so much as the facts of this case don't fit the statute particularly well because it doesn't seem to be the situation the General Assembly was addressing. If, for instance, Ms. Harrison and her friend had experienced something in the hotel the night before where they were with other people who were using drugs who at least vaguely knew them and knew the situation going on, that would be a lot easier fact pattern for the jury to apply and find that the immunity would apply here. In this circumstance, it's lacking that context. And so the jury did have some questions about what is an emergency drug overdose. Were the police called here on an emergency drug overdose or a welfare check? And in response to that question, the judge said that this was a factual issue for them to determine, which was the correct answer, and they determined it, and they concluded that immunity did not apply here. We have the benefit of hindsight, and we know that there were drugs involved here, but a reasonable person encountering this situation would not necessarily reach that same conclusion, and the jury did not reach that conclusion here, which was supported by the evidence. If the court,
I take it the prosecutor did not present any evidence going directly to what a reasonable person might or might not infer. This is essentially all argument based on essentially undisputed testimony.
that's correct. It was argument based on the manager's testimony. Her testimony was internally inconsistent, and so the jury needed to make some factual resolution with that. But there was no expert testimony or medical testimony about what drug overdoses look like, nothing of that. If the court has no further questions, I would ask that the convictions be affirmed. Thank you.
Just a few points that I want to respond to. The evidence does not support that Ms. Harrison and her friend were simply sleeping. The porter, who Ms. Roberts testified was a large individual, banged heavily on the table, and they didn't move, they didn't even flinch. That's not sleeping. That is a different state of consciousness. They tried to wake them multiple times. The officer, who while maybe the staff at the Burger King just shook her lightly, the officer testified that he had to shake her very hard to wake her up. This is not simply the same as being tired. And the fact that she was able to order her food and she just looked tired, that's not when the overdose was occurring. The question is, when she was passed out in that booth, what did that look like? And that is an acute condition that a reasonable person would believe to be drug-related. The statute does not require that a person to see paraphernalia or know that it's drug-related. That would be in the statute. The question is just whether a reasonable person would believe that to be true.
But why reasonableness, negligence cases, for example,
Sure.
is a quintessential task of the jury to resolve. Why couldn't the jury have concluded that a reasonable person would think there were other medical conditions in play here?
It's the prosecution's burden to disprove this, and there was no evidence that there was anything else that this could have been. All we have is two teenagers who are completely passed out in a Burger King on a Thursday morning at 10 a.m. I can't think of what that would be if I saw that situation, especially in these times. And the legislature has made a choice that, given the opioid epidemic, it wants to encourage people to call. We have to interpret this statute to be slightly more broad to effectuate the purpose of saving lives. It made the choice that in these situations, it's more important to save a life than it is to prosecute someone for minor drug possession. So here, if that's the situation that we're looking at, I think most reasonable people would look at that, would believe that to be drug-related, given the context that we're generally living in right now and what they appeared to be. I don't think that you need to see, you don't need to pass out with a needle in your arm to get the benefit of this statute. It's just not in the requirements. The Attorney General noted that it was dispatched as a welfare check, but it was also dispatched as two teenagers passed out, not sleeping. That was part of the testimony, that it was for people passed out. And the fact that dispatch said it was a welfare check doesn't negate what Ms. Roberts' call was. Her testimony when she called was that she called because she had two teenagers who could not wake them up, and she was concerned for their well-being. That's what she said. That's what the purpose of her call was for.
If we're looking at this objectively, though,
Correct.
isn't everything, a lot of what both of you have argued completely irrelevant? I mean, you know, how dispatch coded the 911?
Correct. I think
you know,
that's completely
What the
relevant.
officers may or may not have thought when they got there, you know, whether the officers couldn't wake up one but succeeded in waking, I mean, isn't all that completely irrelevant?
Well, I think what is relevant is that the officers who testified as lay witnesses believed that so all we have is Ms. Roberts' testimony, who said she didn't know it was drugs, but then we have the officers who said when they looked at Ms. Harrison and her friend, they believed they were on drugs. I think that speaks to whether a reasonable person who does have the experiences that Ms. Roberts doesn't have, that would look at these two teenagers and think this is drug-related. So I do think that is relevant. I mean, I think the question is, in this context, so yes, a lot of it doesn't necessarily speak to the question, but the question is, you have to look at these people passed out in a booth and what that would say to a reasonable person. There was no evidence that Ms. Harrison appeared to be homeless or that that was a reasonable conclusion that someone could have believed. There simply wasn't evidence to support that. The idea that Ms. Roberts isn't the person that this statute is meant to speak to, I don't think that's supported by the language. While yes, maybe the impetus of the statute was to get people who wouldn't ordinarily call, the language of the statute is broader than that, because again, it wants, if you see something, say something. It wants you to call if you think there's any possibility that that person might need help, and it doesn't want you to have to be concerned about whether you're getting them in trouble or yourself in trouble. So I don't think this only speaks to two drug co-conspirators or two people who are doing drugs together. It's not in the language of the statute. And nothing about the statute excludes Ms. Roberts from being a good faith reporter. And her testimony, my last point, her testimony was not inconsistent. She was clear the entire time that all she wanted to do was get help. Thank you, and ask this court to vacate Ms. Harrison's convictions.
We appreciate the arguments of both counsel. This case stands submitted. We will issue a written opinion in due course. Counsel in this case are excused. When the tables are cleared, counsel in our next case may set up. Well, I guess that cleared the benches.
Not as popular.
Yes, or not as interesting. In either case, we are ready when you are, gentlemen.
I heard I can adjust this.
It's correct.
Good morning. May it please the court. I am David Chipman, counsel for the defendants below and the appellants here. In addition to addressing your questions today, I'd like to address some of the unique facts here. And based on those facts, the law of the case doctrine, and then the question of what the trial court here, based on the facts of this case, was required to review before granting summary judgment. As the panel saw from the briefs below, this is a case about the sale of cattle. The plaintiffs are the sellers of the cattle. The defendant, JBC, is a buyer of the cattle. There are identical contracts with each plaintiff. Each contract called for a down payment. Each contract required that the seller send weekly reports to the buyer about the cattle's care and feeding. Each contract called for a meeting in January 2016 to inspect the cattle, weigh them, and deliver them.
Now, the down payment was not made, and a dispute arose between the parties about whether the deadline for that down payment had been extended. The plaintiffs did not deliver the weekly reports that they promised, and a dispute arose about that too. Nevertheless, at the plaintiff's invitation, JBC showed up in January of 2016 to inspect and weigh and take take delivery of the cattle. But a dispute arose about that too, specifically about whether the cattle had met the GAP 4 certification that the contract required. Both sides at the time agreed that they were ready, willing, and able to perform. But they were arguing back and forth about which side was ready, willing, and able to perform. So this lawsuit ensued, and what happened next is unique from any of the cases either party cited in any of the briefs. After discovery is completed, defendant JBC filed a motion for summary judgment. Accompanying that motion was an affidavit from defendant's principal, Ty Jacober. The affidavit was comprised of 21 paragraphs detailing all the contract disputes, whether the down payment deadline had been extended, whether the weekly reports had been delivered, whether the cattle on the delivery date were compliant with the GAP 4 and other requirements of the contract, and whether the other side had provided reasonable further assurances. Now, the plaintiffs responded with their own affidavits. And these were detailed affidavits as well, covering the exact same contractual issues. The court carefully considered both affidavits, competing affidavits, and determined in a reasoned order that based on the conflicting evidence, genuine issues of material fact existed about who breached the contract first, about whether further assurances were required, and whether further assurances were presented. The fact disputes identified by the court as being genuine issues of material fact precluded summary judgment for both sides because they all related to the same underlying contractual disputes that I just went over. And the affidavits all address those exact same disputes. So the case was headed to trial. Now, another important fact, trial was put off till 2018 for two reasons. One, the court was double booked, and they couldn't take the trial on the July 2017 date. And the second reason is because JBC lost its counsel, because it had fallen behind in its ability to pay fees. After that, nothing happened, except JBC working to pay its counsel so they could re-engage them and get ready for trial. Then, out of the blue, plaintiffs filed a summary judgment motions on the breach of contract issues, the same breach of contract issues that the court already ruled on a few months later. The same issues that the competing affidavits had already addressed. In fact, they presented less evidence, no new evidence. No new evidence had occurred, no new discovery had occurred. In fact, these affidavits were smaller in substance. Other than addressing, damages which had not been addressed previously, these affidavits were bare-boned and conclusory with respect to these four contract issues.
Did the seller's summary judgment briefs remind the trial court that there had been a prior summary judgment motion in order?
No, they did not. In fact, just the opposite. The plaintiff's summary judgment briefs, recognizing that the defendants did not have counsel and couldn't appear, they pretended that the prior summary judgment brief did not exist. They pretended that the Ty Jacober's affidavit did not exist, and that the court's prior order did not exist, and unfortunately, the trial court took the same approach and just signed the plaintiff's order that they had submitted, which brings me to the law of the case doctrine. That doctrine says that a trial court may exercise its discretion to depart from an earlier ruling in a case if following it would be an error, and two, The decision is no longer sound because of changed circumstances. These two orders of the court cannot logically coexist.
Does the law of the case doctrine even apply to a ruling on a summary judgment?
It applies to a ruling that there is a genuine issue of material fact because, as we stated in our reply brief, that ruling is a question of law. The law of the case doctrine does not apply to factual decisions, but it does apply to questions of law.
Even if they're resolved in motion practice as opposed to entry of a final judgment on the merits?
Well, the finding that there are genuine issues of material fact is a question of law. And since it applies to those questions of law, I propose, yes, it does. It does apply here. And importantly, the court made no indication that the prior ruling was in error. The court didn't even mention the prior ruling. In fact, if you look at looking at the affidavits and considering the affidavits de novo, it demonstrates there's no way you could have looked at those because those affidavits, I don't think it's disputed. The competing affidavits preclude summary judgment for either side. Nor did the court identify any change. Did you have a question?
Yes. If neither side pointed out to the court that there was already this previous summary judgment, is it incumbent on the court to go back into the record and look for that on its own?
That leads me to the second policy question, the more broader question. I will point out, just before that there was no additional evidence here presented to the court, no changed circumstances whatsoever. The court simply did not consider his prior, just a few months earlier. And again, importantly, this is not a case where there was a lot happening in between these summary judgment motions, nor is this a case where the evidence was voluminous, just a few pages. Which leads me to your question, and that is, let's visit that broader policy issue of what a trial court is required to review before granting a motion for summary judgment. More specifically, what does Rule 56C mean when it says you cannot grant summary judgment unless the affidavits, the depositions, and the other documents on file show that there are no genuine issues of material fact. The parties argue back and forth about which standard would apply. Our side, the defendant, argues that Colorado says, using the Cotter Corporation case as its indicator, that Colorado says on file means in the record. That you can't just look at the four corners of the summary judgment motion presented. The plaintiffs, they argue differently. They want this court to adopt the approach that federal courts take. And the federal court says, well, you have discretion. You may go beyond in certain circumstances. In certain circumstances, you can just look at the four corners of the summary judgment motion. Look, regardless of which approach the court elects to take, in these circumstances of this case, where there was a recent summary judgment order on the exact same contractual issues, that is JBC's issue with the two plaintiffs, where were clear disputed affidavits and contrary affidavits that the court had carefully reviewed and written a reasoned opinion about, and no new evidence in the interim, at the very least, regardless of which approach you take, the court was required to consider his prior ruling and at least look at Ty Jacober's affidavit in that clearly precluded summary judgment.
Why was it required to look at the Jacober affidavit if we adopt the federal rule that a trial court's mandatory review is limited to matters identified in the summary judgment motion and response, if any, and here there wasn't one?
Because the federal approach is a question of discretion. It's an abuse of discretion standard. It doesn't mandate that they only look at that motion. It doesn't mandate that they go beyond it. It gives the court discretion.
Okay.
And under these circumstances, these specific circumstances, that discretion was abused.
Well, help me understand exactly what, if we adopted the federal approach, exactly how did the lower court here abuse its discretion by not going back to the Jacober affidavit?
Because under these circumstances, right, one, he's granting summary judgment. So the Colorado's clear that summary judgment is still a very drastic remedy. When you grant summary judgment, you better be sure that there are no genuine issues of material fact. And you have to look at the file, and that's what Rule 56C says. This court did not have a lot of evidence to peruse. Nothing had happened in this case. This court had already reviewed these affidavits on file. He had already considered them. He had already ruled that genuine issues of material fact existed. And under those circumstances, it cannot be anything but an abuse of discretion for him to pretend that they don't exist and to basically treat this motion as confessed. Your Honors, I'm going to use the remainder of my time for rebuttal.
May it please the court, my name is Jordan Thacker, and I represent Southern Cross Ranches and Ranch Management. With me at council table is Attorney Rachel Sternlieb. Rule 56E provides that when a motion for summary judgment is made and supported, the opposing party must set forth specific facts showing a genuine issue for trial. If there is no response, summary judgment, if appropriate, shall be entered. The trial court followed that rule precisely. Plaintiffs filed a motion for summary judgment supported by affidavits by those with knowledge and the plain language of the contract. There was no response. Summary judgment was appropriate because plaintiffs met their initial burden and defendant did not meet its burden, and therefore, pursuant to the last sentence of Rule 56E, the trial court was required to enter summary judgment under these circumstances.
Let me ask you this, I'm sorry.
Go ahead, no, go ahead.
What changed to allow the trial court to reverse its position on whether there were genuine issues of fact from the first summary judgment?
Nothing changed, and the trial court did not reverse its position. The trial court's order granting summary judgment is wholly consistent with its earlier order denying JBC summary judgment. The court made the following findings in its earlier order denying summary judgment: that the purchase agreements were unambiguous and required JBC to make an initial payment of $310,000 on October 5, 2015, that JBC did not make that initial payment as required, and that JBC admits that it did not make the initial payment as required. Those facts are consistent with the court's later finding that JBC breached the agreement by not making the initial payment as required. The court denied summary judgment to JBC on the basis that JBC did not meet its burden of proving that it did not engage in a prior material breach. In order for JBC to prevail on its motion for summary judgment directed at conduct that it observed in January of 2016 that it claims gave rise to a breach, it had to demonstrate that there were no disputed issues of material fact, that it did not engage in a prior material breach in October by failing to make the initial payment.
Isn't that inextricably intertwined with the assertions in the Jacober affidavit that the initial payment deadline had been extended? And this is a two-part question. And didn't the trial court find there were disputed issues of material fact concerning extension of the payment deadline?
No. And I think the clearest way to read the earlier order is the court concluded that there were no disputed issues of material fact on that point. The court said in the initial order that Mr. Jacober avers that the payment deadline was extended by an email. Now, I'll tell you that that is a naked allegation in the affidavit. No email was attached to the affidavit, and there was no email in the record. So it's simply Mr. Jacober saying that an email exists when there's no evidence that the email exists. But the trial court, in its prior order on summary judgment, addressed that and then said that the purchase agreements are unambiguous and require payment by October 5th, 2015.
Wasn't one of those agreements not even executed until a month or so after October 15th?
Yes, and the trial court addressed that in its initial order on summary judgment and concluded again that irregardless, unambiguously, the contract required payment by October 5th, 2015, that there was no prior performance required by plaintiffs before that initial payment was to be made. And the payment was not made. So on those factual findings, the court denied JBC's motion for summary judgment. Those very same factual findings support the later conclusion that JBC breached the contract by failing to make the initial payment. Nor is there a issue with a prior determination of law. The legal conclusion drawn by the court in its initial order is that a reasonable jury could conclude that JBC committed a prior material breach.
Counsel, I have a question. Were any of the weekly reports that opposing counsel mentions due before the first initial payment?
No. No performance was required before the first initial payment. Indeed, the evidence in the record is that plaintiffs required that initial payment of $310,000 in order to perform the tasks of finishing the cattle. But that was not contained in the court's earlier order. But the court's earlier order is fully consistent with its later order. Now, JBC argues that the court had an independent duty to search the record for evidence favorable to it. So first of all, that is not in the rule. Nothing in the rule says that the court has any obligation to scour the record for evidence favorable to one side or the other. To the contrary, the rule says expressly that the opposing party must point the court to specific evidence. And so the rule contemplates that the court is only going to review the evidence that is presented by the parties.
Well, did it have an obligation to review the previous summary judgment order?
I don't think it had an obligation to, and we don't know if it did or it did not. There's no evidence to suggest that the court did not review its earlier summary judgment order.
In your briefing on the second summary judgment motion, did you alert the court to the fact that it had previously denied a summary judgment motion on similar issues?
So I wasn't counsel below, but no. Below, there was no effort to alert the court to the fact that JBC had previously filed a motion for summary judgment that was denied. Notably, plaintiffs had not previously filed a motion for summary judgment. I think if this was a second bite at the apple that plaintiffs were attempting to take, that ethically they should alert the court to the fact that this is a second motion for summary judgment. But I don't think that counsel below had an obligation to tell the court that the opposing party had previously filed a motion for summary judgment, and there was nothing unusual about this motion for summary judgment. The pretrial order that was in effect imposed a deadline of 13 weeks prior to trial to file motions for summary judgment. Plaintiffs filed their motion for summary judgment timely under the prevailing PTO. They, before filing, sent a written communication to JBC advising JBC that they were going to file. They sent a copy of the motion to JBC after it was filed. The court, in allowing JBC's counsel to withdraw, had engaged in a substantial colloquy with Mr. Jacober, advising Mr. Jacober of the consequences that the entities would be unrepresented. The court vacated the trial and set it for 7 months down the road to allow JBC to acquire new counsel. JBC was obviously familiar with the consequences of a motion for summary judgment being granted, having filed its own motion months prior. So the trial court did everything appropriately here, both pursuant to Rule 56, pursuant to due process concerns, and pursuant to the prevailing pretrial order in the case. JBC failed to get counsel, and the rule is that an entity cannot be represented pro se. An entity must have counsel. To the extent there's prejudice here to JBC, it's not because of anything the trial court did in error. The trial court acted appropriately. To the extent there's any prejudice here, it's because JBC did not obtain counsel until the day after the court entered summary judgment, and then JBC was able to obtain counsel and seek to undo the ruling that had already come down.
Let's assume, just for purposes of my question, that the trial court had looked at the Jacober affidavit. Would that affidavit have created a disputed issue of material fact?
No,
And why not, please?
because the court could have still concluded that there were no disputed issues of material fact as to any of the elements of breach of contract as to which plaintiffs had the burden. There was a contract, undisputed. JBC failed to make its initial payment under the contract. That was admitted. There was no prior performance required by the plaintiffs. That didn't require an affidavit. That just required looking at the plain language of the contract before it. There were damages. Jacober affidavit does not address damages as to plaintiffs. The plaintiff's affidavit sets forth the calculation of damages. Exhibits 2 and 4 to the motions for summary judgment contain a detailed calculation of damages which were adopted in the plaintiff's affidavits. So all 4 elements of breach of contract could have been found to lie without a disputed issue of material fact, regardless of the Jacober affidavit.
Well, what about the Jacober affidavit's assertion that the original payment deadline had been extended by agreement of the parties?
I think the court did find, and was correct in finding, that that did not create a disputed issue of material fact. The court found that in its initial order on summary judgment. And because Mr. Jacober simply said that, asserted that in one line of his affidavit, asserted that the parties by email agreed to extend the initial payment deadline. And there was no email. And the purchase agreement itself is an integrated document that is unambiguous in requiring initial payment by a date certain. The court correctly determined that the assertion by Mr. Jacober that there's a writing unproduced that changed the contract's terms did not create a disputed issue of material fact. And then with respect to the counterclaims made by JBC, JBC had the burden of proving those counterclaims. On summary judgment, all a moving party that does not have the burden has to do is point to the absence of evidence in the record with respect to one or more essential elements underlying the non-movant's claims. And then it's the burden on the non-movant to show that there is at least some evidence supporting its affirmative claims. The plaintiffs met their burden by showing an absence of evidence in the record on the tort counterclaims, and defendants did not respond. A trial court, ought not to be tasked with searching the record for evidence that supports a party's affirmative claim and helps a party meet its burden of proof in order to allow that claim to survive. But stepping back for a moment, more broadly, the kind of approach that JBC is urging here turns appellate procedure on its head. Under JBC's approach, a party could sit on its hands at the summary judgment stage, not respond, not point the trial court to evidence creating a fact issue, and then on appeal, point this court for the first time to that evidence, say that the court below erred by not finding that evidence on its own, and then this court is in the position of reviewing evidence for the first time before the trial court had an opportunity to review it, analyze it, and opine on it. That is not how appellate procedure is supposed to work. JBC had an obligation under Rule 56E to respond to the motion for summary judgment and point the court to specific facts. In failing to do so, it ran the risk that if plaintiffs met their initial burden of proof, summary judgment would be entered against it, pursuant to the plain language of the rule.
Even if we accept your view and the federal view, did the trial court have an independent obligation to explain and reconcile its two potentially inconsistent summary judgment orders?
No, for one, it's not inconsistent. And second, it was not presented in the motion before it.
Well, under the law of the case doctrine, isn't the court at least required to explain a prior ruling, a departure from a prior ruling?
If the court departed from a prior ruling, but the court did not depart from a prior ruling, a denial of a motion for summary judgment does not establish law of the case. Perhaps a grant of a motion for summary judgment or a grant of a motion for determination of a question of law would, but not a denial of a motion for summary judgment. And so, no, the court was not obligated to reconcile a prior denial with a current grant any more than it's required to reconcile rulings on cross motions for summary judgment, which it is not required to do.
Thank you.
Thank you, Your Honors.
Correcting a couple of points here. The first order for summary judgment absolutely, positively found that genuine issues of material fact existed about whether the deadline on the down payment had been extended. That's found on pages 878 and 879 of the record. I will read. JBC has not met its burden to show that there is no genuine issue of fact as to whether the parties entered a separate agreement to change the terms of when the initial payment was due. A genuine issue dispute exists as to whether JBC breached the purchase agreements first. The court absolutely found that there were genuine issues of disputed fact with respect to that very issue, and its second opinion is entirely inconsistent with the first.
Did the Jacober affidavit attach the referenced emails?
It did not.
Okay.
But this is why we
that's
have,
unknown,
yeah,
essentially.
this is why we have trials. We don't try the case at the summary judgment level. It is undisputed that notwithstanding everything that happened, the plaintiff still invited Mr. Jacober out in January to inspect the cattle and to weigh them. So there's disputes about why that happened. This is why we have trials. This is why summary judgment is a drastic remedy. And the Colorado Supreme Court makes it clear that you do not grant summary judgment until you've reviewed all the evidence on file. Now, I know trial courts are very busy. They are overloaded, totally get it. But in this instance, it wasn't burdensome. Please look at the Cotter case and the direction the Cotter case gives on this issue, which Cotter case occurred years after the federal cases that plaintiffs cite in the 10th Circuit. Cotter says you have to be sure from the evidence on file that there are no disputed issues of fact. In this instance, the evidence was minimal. It was not significant. This court, just a few months before, had reviewed this evidence carefully. These orders are entirely inconsistent and cannot be reconciled one with the other. A couple other quick points. Yes, counsel hired us shortly after the ruling occurred. We're the stopgap. We're not owed $175,000. And finally, please remember that the trial court told Mr. Jacober, we're going to trial. You can get counsel anytime you want between now and the time of trial. no indication that there would be another round of summary judgment motions while he's unable to appear. Thank you, Your Honors.
We appreciate the arguments of both counsel. This case stands submitted. We will issue a written opinion in due course. This case exhausts our morning special session. Again, we appreciate counsel's helping us reschedule this. The bailiff may announce a recess.
All right.